A lease, it's so much more than just a piece of paper. It's a really high stakes agreement. For a landlord, you're talking about protecting a huge asset. And for a tenant, well, it could be their home or their entire business. But what happens when the rules get broken? Well, that can trigger one of the most powerful and final remedies in all of property law: forfeiture.
And that's really the central question, isn't it? A promise is made, a contract is signed, but what happens when that promise gets broken? And we're not just talking about a late rent payment here. We're talking about breaches so serious they can put the entire lease on the line, leading to a really dramatic and decisive end.
So here's how we're going to break it all down in this explainer. We're going to follow the story of a lease in crisis. We'll start with the promises themselves, see what happens when they're broken, and then dive into the landlord's, let's call it, nuclear option of forfeiture. And finally, we'll look at the two potential lifelines for a tenant: waiver and relief. Okay, first things first, we have to understand what any lease is built on. At its very heart, a lease is just a collection of legally binding promises between the landlord and the tenant. And these aren't just polite suggestions. They are the absolute law of that property. Now, the official legal term for these promises is a covenant. The easiest way to think of them is as the fundamental rules of the game. They spell out exactly what each side has to do to hold up their end of the bargain, from paying rent all the way to maintaining the property. These covenants are the very backbone of the relationship. And the range of these promises is pretty fascinating when you look at it. You've got the really obvious ones, right? Like paying rent on time. But then you get into covenants that are way more complex, like the promise to keep the property in good repair. And it's this specific promise, that duty to repair, that so often becomes the flashpoint for huge disputes. So, what actually happens when a tenant fails to keep the property in repair? You might think that just means, fixing a leaky faucet or something. But let me tell you, the legal standard is way, way higher than that. This quote from the classic case of Lurcott v. Wakely, it's just staggering. Think about what it's saying for a second. A general promise to repair isn't just about patching things up. It can literally mean a tenant is legally on the hook for replacing major parts of an old building, piece by piece, until it's practically brand new. The responsibility here is just immense. And here's the real kicker. The standard isn't about keeping the property as it was. Thanks to this case, Proudfoot v. Hart, the rule is that a tenant has to bring the property up to a standard that a new, reasonable tenant would find acceptable. Just imagine that. Even if the place was a total wreck when you moved in, the burden is on you to fix it up and even replace whole things like worn-out flooring. So the tenant has breached a really serious covenant, like the duty to repair. What can the landlord do? Well, they can sue for money, of course, but there's a much more powerful and, frankly, final option in their toolkit, and this is where we introduce forfeiture. Let's be super clear about this. Forfeiture isn't just an eviction notice because you missed a rent payment. It is the landlord's right to completely terminate the entire lease agreement. It ends all of the tenant's rights to the property and lets the landlord take it back, period. For a tenant, this is the absolute worst-case scenario. Now, on the surface, the process looks pretty simple. A rule is broken, a formal warning is sent, and if it's not fixed in time, the landlord re-enters and the lease is over. But don't be fooled. Within these 4 simple-looking steps lies a complete minefield of legal complexities and potential missteps for both sides. And this brings us to the first big twist in our story. Just because a landlord has the right to forfeit doesn't mean they can't lose it. A landlord's own actions can accidentally hand the tenant a get-out-of-jail-free card through a cool legal concept called waiver. Think of it this way. A landlord just can't have it both ways. They can't act like the lease is over by trying to forfeit, while also acting like the lease is still totally valid by, for example, accepting next month's rent. If they accept rent after they know about a breach, they have waived their right to forfeit for that specific issue. They've basically sent a message that says, hey, we're still in business. Okay, but here's where it gets a little tricky. Let's say a property is in disrepair, a clear breach. The landlord sends a notice giving the tenant 3 months to fix everything up. Now, by giving the tenant that time, has the landlord recognized the lease as continuing for those 3 months, and in doing so, waived their right to forfeit right away? What do you think? And here's where property law just gets brilliantly nuanced. The court in Few v. Perkins said no, that is not a waiver. And you may be asking, why? Well, it's because failing to repair isn't a one-and-done kind of event. It's what's called a continuing breach. It's a fresh breach every single day the property stays in disrepair. So that notice to fix some specific things doesn't cancel out the big underlying ongoing failure. It's wild, but in theory, a landlord could send that notice and still legally move to forfeit the very next day. So if the landlord hasn't waived their right, is that it? Is the tenant just out on the street? Well, not necessarily. This is where the courts can step in with an extraordinary power, the power to grant relief against forfeiture. This is the tenant's absolute last hope.
Now, it's absolutely crucial to understand the difference here. Waiver is like a technical knockout, something caused by the landlord's own mistake. Relief, on the other hand, is a conscious decision by a judge. It's the court stepping in and using its power of fairness, what lawyers call equity, to look at the entire situation and decide if ending the lease is just way too harsh a penalty.
But getting relief is not a given, especially not for disrepair. As Lord Eldon explained way back in the case of Hill v. Barclay, there's a huge difference between just giving a landlord money and actually fixing a deteriorating building. A landlord can sue for damages, sure, but that money doesn't stop the property itself from falling apart. And that's why courts are often pretty reluctant to grant relief for repair breaches, because it doesn't really make the landlord whole again. So when will a court step in? Well, they're going to look at the whole picture. Was the breach just a simple, honest mistake? Is the tenant ready and able to fix it right now and pay for any trouble caused? Has the landlord been acting unfairly? It's a real balancing act, a judgment call based on what is fair and just in that one specific situation. All right, we have been through the fire of a lease dispute. So let's pull back for a second and look at the most important things to remember from this whole dramatic process. Okay, let's boil it all down. Covenants are serious, legally binding promises. The duty to repair is incredibly demanding. Forfeiture is the landlord's ultimate weapon. But, and this is a big but, that weapon can be disarmed, either by the landlord's own actions through waiver or by a court's sense of fairness through relief. Ultimately, the law of forfeiture is this constant tug of war. It's trying to give landlords a real way to protect their investment from neglectful tenants, while at the same time providing safety nets to prevent tenants from losing their homes or businesses over something minor or fixable. It's a really delicate and often pretty contentious balance. And that leaves us with one final thought to chew on. In today's world, is this incredible power to just completely terminate a lease still a necessary tool for landlords? Or is it an outdated and overly harsh penalty that maybe needs some reform? It's definitely something to think about.